Welcome to this episode of Term Talk, the Federal Judicial Center's video podcast discussing the terms Supreme Court opinions likely to have the most impact on lower courts. I'm Jim Chance, Senior Judicial Education Attorney at the FJC. I'm fortunate to be joined by Laurie Levenson, Professor of Law, and David W. Burcham, Chair in Ethical Advocacy at Loyola Law School, and Evan Lee, Emeritus Professor at UC Law, San Francisco. Thank you both for joining me for the second of two criminal law discussions. Gutierrez versus Saenz is almost identical to an earlier case, Reed versus Getz. It seems like a summary reversal, but can you tell us the reasons the Fifth Circuit denied standing in this case despite Reed?
Yeah, it was a little unusual because it wasn't that long after Reed, and as you said, it's very similar. On the facts of this case, the defendant Gutierrez was convicted and sentenced to death for killing a woman in her home in order to steal $500,000. He wanted DNA tests to show that, in fact, he wasn't in the home. But Texas said they allowed the death penalty if the defendant caused, intended, or anticipated a life would be taken. And therefore, under Texas's standard, the DNA testing would not refute his conviction, and they denied that it would impact the sentence. And they said that the defendant could not use Article 64 in that state, which had a procedure that you could use testing, but only if it would determine innocence of the underlying crime, not just reduce the sentence. So in fact, Gutierrez brought a 1983 claim and asked for a declaratory relief that it would violate due process to not allow him to have this DNA testing. And the district court agreed. But the Fifth Circuit did not. They reversed the district court on the findings of standing, on the unconstitutionality of the DNA testing procedure, and they addressed the reinstatement of whether you need a declaratory judgment or not. So this is a case that came right after Reed, looks a lot like Reed, but nonetheless the Fifth Circuit was not prepared to allow the DNA testing.
And Evan, the Supreme Court reversed 6-3, with Justice Sotomayor writing the opinion, joined by the Chief Justice, Justice Kagan, Justice Kavanaugh, Justice Barrett, and Justice Jackson. What did they find wrong with the distinction?
Part of the problem, the majority said, was that the Court of Appeals focused on the wrong thing in its redressability analysis. It shouldn't have focused on the declaratory judgment that the district court actually entered. It should have gone back to Gutierrez's original prayer for relief in his complaint, because after all, Article 3 standing asks whether the plaintiff's request for relief would redress or remedy the plaintiff's claimed injury. But the bigger problem, according to the majority, was that the Court of Appeals treated the redressability analysis as a straight probabilistic exercise, or as the court characterized it, a guess as to whether a favorable court decision will in fact ultimately cause the prosecutor to turn over the evidence, end quote. The majority concluded that this probabilistic analysis was the very same problem that prompted the Supreme Court to reverse the lower court 2 years ago in Reed versus Getz, the case that you and Laurie have been talking about, which also involved Texas Article 64. And there, in a majority opinion by Justice Kavanaugh, these same 6 justices in the majority of this case held that the plaintiff's broad constitutional challenge to Article 64, if successful, would redress his claimed injury by eliminating Article 64 as a reason for denying DNA testing. And Justice Sotomayor found that Gutierrez's broad constitutional challenge to Article 64 similarly would, if successful, redress his claimed injury. The fact that a prosecutor might eventually find another reason to deny a prisoner's request for DNA tests doesn't vitiate his standing to argue that the law violated his due process rights. The next thing I'm going to say is a little inside baseball, but it matters to Justice Barrett, so I'm going to mention it. Justice Sotomayor at this point cited 2 standing cases from the administrative agency context, FEC versus Akins and Lujan versus the Defenders of Wildlife. Justice Barrett made a point of not joining this part of the majority's opinion. characterizing those two cases as adopting a, and I quote, somewhat relaxed redressability inquiry in administrative law procedural injury cases, end quote. And she warned that by invoking these two cases, and again, I'm going to quote from her, in the unique context of requests for DNA evidence from Texas prosecutors, the court muddies the waters of standing doctrine.
Laurie, Justices Thomas and Alito wrote separate dissents. Tell us what they said.
Right. Justice Thomas said, look, the federal court should not be involved in this case. It's not warranted. These post-conviction procedures are not required. And the fact that there are such procedures do not create a liberty interest that should be upheld in a case like this. Justice Alito, who was joined by Justices Thomas and Gorsuch, said they misapplied the retest. They acknowledged that the retest was done just a few years earlier, but they went on to distinguish Gutierrez's case from Reed. And the court determined it is likely that the prosecutor would comply.
So what should the lower courts take away from this case?
I think that the lower court should take away, if there are post-conviction processes, particularly things like DNA, they can't be unfairly limited, and that you have those for a purpose, and you should use them if you say that you will.
Evan, do you have another take on this, or are you in agreement?
I'm in agreement. I would say, at the very least, what this case says is that Reed versus Getz lives.
Good. All right, let's talk about Andrew versus White. So rather than seeking more evidence, this case involves objections to the inclusion of prejudicial evidence. And in a 7-2 per curiam decision with Justices Thomas and Gorsuch dissenting, the court clarified what is dicta and what is holding in the context of determining what is clearly established federal law. Evan, this case revolves around the admission of what the state admitted was irrelevant evidence of a defendant's sexual conduct, but a disagreement as to whether it was overly prejudicial and whether there was precedent to find it in violation of her due process rights. Help us understand how these issues were developed in the case and what the court ultimately determined.
Well, let's start with the facts. Brenda Andrew was tried for murdering her husband to get the insurance proceeds. Now, the fatal shot was actually fired by her then boyfriend. The prosecution introduced all kinds of salacious evidence about her active sex life going back 2 decades, how she dressed provocatively when dining out, how many times she had had sex in her car, and so on. She was convicted and sentenced to death. After the Oklahoma appellate courts upheld her conviction and sentence, a federal district court denied habeas relief under Section 2254D, and the 10th Circuit affirmed. Now, Section 2254D permits habeas relief when the state court has relied on an unreasonable determination of the facts, or, as relevant to this case, the state court unreasonably applied clearly established federal law. That source of clearly established federal law must be a prior holding of the U.S. Supreme Court, not mere dicta. The test for whether a state court has unreasonably applied a clearly established rule of federal law is whether no fair-minded jurist would agree. Although some of the evidence about her sex life was irrelevant, as the state conceded, the 10th Circuit held that it was harmless beyond a reasonable doubt because the evidence of her guilt was so overwhelming. Andrew argued that under the Supreme Court's 1991 ruling in Payne versus Tennessee, the victim impact statement case, that, quote, when evidence is introduced that is so unduly prejudicial that it renders the trial fundamentally unfair, the due process clause provides a mechanism for relief, end quote. So that's the rule that we're talking about in this case. And the question is that clearly established? The 10th Circuit says, no, it's not clearly established because it's not a holding. It's dicta. The state won that case in Payne versus Tennessee. It wasn't the defendant that won. But in a per curiam opinion, 7 justices of the Supreme Court reversed In Payne, the Supreme Court considered whether there should be a categorical prohibition on these so-called victim impact statements. And the court said, no, a categorical rule is unnecessary. Why? Because the due process clause always provides a safety net, which is to say, it provides relief in any case where a victim impact statement, or any other kind of evidence for that matter, is so prejudicial that it renders the trial fundamentally unfair. In Andrew versus White, the majority determines that this statement constitutes holding and not dicta.
Evan, tell us about what the dissent said.
Well, they did argue that the court had failed to apply another standard that the court has interpreted in AEDPA, and that is the so-called fair-minded jurist test. So what the dissent said was that you're not using that standard here, that you're just saying it's clearly established. You're not asking whether a fair-minded jurist would find it to be clearly established. But the majority's response to that is, well, you're not using the fair-minded jurist test for the purpose that we promulgated it. The fair-minded jurist test only applies if you've already found a rule to be clearly established. And once it is clearly established, then you can apply the fair-minded jurist test to determine whether the state court reasonably or unreasonably applied that clearly established rule to the case.
Laurie, what would you say to lower courts is the most important thing to take away from this?
Yeah, I think that this case is enormous in the area of post-conviction relief, because when the Supreme Court says that now you can use Payne versus Tennessee to claim that prejudicial evidence is a due process violation, and not only that, that it was clearly established, that means under laws like AEDPA, this type of claim can now be brought. And so in this situation, it was remanded, of course, but for the first time, you have somebody like Andrew who can make that claim and can make it procedurally when before they might have been foreclosed.
Evan, final thoughts?
Well, I agree with Laurie. I don't think many people would have predicted ahead of time that the Supreme Court would have found that rule to have come out of Payne versus Tennessee, and furthermore to have said that it was clearly established. Not saying it's wrong, I just don't think a lot of people would have predicted it. But I do think there's a couple of other important rulings for AEDPA purposes. One is the way they determined that it was clearly established, and then also a clarification of when the fair-minded jurist test applies and to what it applies within the AEDPA regime.
All right. Thank you both for being with us again. We appreciate your insights.